The courtroom looks calm at first, but the moment the defendant begins to speak, everything changes. Instead of answering simple questions, she challenges the authority of the court and claims the law doesn't apply to her. Her words sound confident and dramatic, like something learned from the internet, but inside a real courtroom, they only create tension and confusion. The judge listens for a moment, then makes it clear that this is not a debate club or a stage for personal beliefs. The court operates on real laws, not personal rules. Every attempt by the defendant to avoid responsibility only makes her situation worse. The judge explains that refusing to participate won't stop the case, it will simply move forward without her input. As the pressure builds, the energy in the room shifts. The bold attitude starts to fade, and reality begins to sink in. The judge remains calm, firm, and completely in control, showing that no amount of viral-style arguments can override courtroom procedure. By the end, one thing is clear: the law doesn't care about internet theories or dramatic speeches. In a real courtroom, only facts and legal process matter, and the system moves forward whether you accept it or not.
No, strike that. I apologize. That's not case number. This is case number 174612601, the people of the state of Michigan versus Bonita Ayana Sealy. The defendant is charged with 1 count of assault or assault and battery, and today is the date set for an arraignment on a bench warrant. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 8350505.
All right, ma'am, please unmute yourself. State your name for the record, please.
Islam, I self-law am master, and proper persona, sojourner, or heritage of the land.
Ma'am, I said state your name. I didn't.
I will state for this X-rail. This
ma'am, listen, let me say this to you.
This trade name, no, this trade name.
If you did not come to court, if you didn't come to court to participate in court, please don't come back to my courtroom. So I've muted you, so therefore we can't even hear what you're saying. So let me be clear. If you have not come to court, because let me just be clear. Okay, well, you have a great day. Have a great day. If I didn't think someone had jurisdiction over me, I promise you, I would not even get out of my bed. I promise you. Let me say this. If a person did not have jurisdiction over me, if I believed that a person, that an entity did not have jurisdiction over me, I promise you, I would not get up out of my bed. I would not take a time off of work. I would not stop anything that I was doing for that day to come to court to say these things. Number one, you know it's going to get you nowhere. There is no, it's like speaking Spanish to an English speaking person. Sincerely, from the bottom of your heart, that I nor this court has any jurisdiction over you, ma'am, don't come. You don't come. Because there's nothing, there is absolutely nothing. There is nothing that I can do for you. If you are not interested in proceeding in a manner that we can understand you, if you're going to simply read off some stuff to me, it's equivalent to me going over to England. Since apparently you all don't believe that you're citizens. I don't really care what you believe. It is equivalent to me going over to England, getting arrested, and then telling them they don't have jurisdiction over me. If they let me go home, I promise you, if I didn't think they had jurisdiction over me, I'm not showing up. So okay, so we can try this one more time. If you want to state your name for the record so that we can have the name for the record, then you can state your name for the record. If you're going to say all of that other stuff to me that I don't have jurisdiction, then I'm gonna subside, and I'm gonna go ahead and move on to another case. I am going to remove you from the courtroom because this is going to get us nowhere. Nowhere. Now, by the time you've said all of this, by the time you've done all of this, this is a 2017 case. We probably would be finished with the case by now. Probably would be. Probably would be. Of course, I'm not going to give legal advice. I'm not going to say what she should do and how she should respond. Probably would be finished with this case by now. Okay, ma'am, please state your name for the record. Thank you, Ms. Seeley. Today is the date set for an arraignment on a bench warrant. How are we proceeding?
Innocent.
The court is going to enter a not guilty plea on behalf of Ms. Seeley. I will set this matter for a pretrial conference. This is a child abuse 4th degree case. Strike that. Again, I keep looking down at your client, looking up at your client's case. This is an assault or assault and battery case. The court is going to set the matter for a pretrial conference. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed. Probably could have already been dismissed. I don't know if you have contact with the complaining witness or not, Miss Ritter. However, the complaining witness is required to appear at the pretrial conference. Today is December the 6th. The court is going to set the matter for January the 6th. At 8:35. I'm sorry, 8:25. That denotes the arraignment portion. 8:25. As I indicated, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation for the failure to appear. Bond will continue with no contact with the complaining witness. Anything further?
Nothing from the people, Judge. Thank you.
Anything further, Ms. Seeley?
The courtroom is quiet at first, the kind of silence that feels heavy before something unexpected happens. The defendant walks in not with fear or uncertainty, but with confidence, almost like she's stepping onto a stage. From the very first moment she opens her mouth, it's clear she's not here to cooperate with the process. She speaks in long, complicated phrases, refusing to give direct answers, challenging the authority of the court, and trying to control the direction of the hearing before it even begins. There is a strange tension in the air as the judge listens. The defendant claims the court has no jurisdiction over her, using words that sound powerful and official but don't actually respond to anything being asked. The judge gives her space to speak at first, allowing her to express herself, but it quickly becomes obvious that this is not confusion. This is intentional. The defendant repeats the same ideas in different ways, hoping that confidence alone will somehow change reality. The courtroom staff remain calm, watching closely. The judge's patience is steady but not unlimited. The law is not a conversation where everyone gets to define their own rules. The judge reminds her that the courtroom is not a place for personal belief systems. You can believe whatever you want, but belief does not erase legal responsibility. The defendant continues to interrupt, speaking over the judge, repeating phrases that seem memorized rather than understood. The tension rises as the judge explains that refusing to participate does not stop the case. The system does not freeze because someone disagrees with it. The case will move forward whether the defendant chooses to cooperate or not. The defendant's confidence begins to look less powerful and more desperate. The dramatic tone that might impress an online audience carries no weight here. The judge remains calm, grounded, and focused, refusing to be drawn into arguments that led nowhere. As the exchange continues, the difference between fantasy and reality becomes painfully clear. The defendant is trying to speak her way out of a process that runs on rules, not words. The judge points out that showing up in court while claiming the court has no authority is a contradiction in itself. The room grows quieter. The defendant pauses, as if realizing that none of her statements are changing the situation. The judge gives a clear warning. The courtroom will not turn into chaos. If the defendant refuses to cooperate, she will be removed, and the case will continue without her voice being heard. That moment changes the energy in the room. The performance begins to fade. The confidence softens. The defendant looks less like someone in control and more like someone facing consequences she can't talk her way out of. For a long moment, the defendant continues to resist, but the judge does not move. There is no anger, no shouting, just firm authority. The law does not need to raise its voice. The law waits. Eventually, the defendant gives in to the reality of the situation. The simple things she refused to say earlier finally come out. Her name is stated. The record is made. The process continues. The courtroom returns to its rhythm. Charges are acknowledged. Procedures move forward. The future court date is set. What began as an attempt to dominate the room ends with quiet compliance. The transformation is subtle but powerful. The room no longer feels chaotic. It feels structured again. The judge remains professional throughout, never mocking, never losing control, simply guiding the process back onto its proper path. There is something deeply revealing about moments like this. Online, certain ideas are presented as secret knowledge, as if there are magic words that can make legal trouble disappear. In reality, these ideas collapse the moment they touch the real world. The courtroom is not impressed by confidence without substance. It does not respond to rehearsed phrases. It responds to facts, procedure, and lawful authority. The defendant came in believing she could redefine the rules simply by refusing to accept them. What she encounters instead is a system that does not need agreement to function. The judge does not argue philosophy. The judge enforces process. The difference between belief and reality becomes clear. You can reject the system in your mind, but the system does not vanish because of it. The emotional shift is noticeable. The early defiance gives way to quiet resignation. The defendant no longer interrupts. The words become shorter. The body language changes. The performance ends. What remains is a person standing inside a process she tried to deny. The courtroom does not celebrate this moment. It simply moves forward, because that is what it is designed to do. This is how order is maintained, not through shouting or humiliation, but through consistency. The judge does not need to win an argument. The judge only needs to keep the process intact. The defendant's attempt to control the situation dissolves under the weight of reality. The law does not bend to confidence. It does not bend to volume. It bends only to proper legal process. The silence that follows feels different from the silence at the beginning. This silence is not tension. It is acceptance. The courtroom continues with its work, unaffected by the earlier disruption. The moment passes, but the lesson remains. In the real world, authority is not defeated by slogans. Consequences are not erased by confidence. The system moves forward, steady and unbothered, whether you believe in it or not.